Welcome to the deep dive. Today, we're jumping straight into a really critical tool in international trade safeguard measures.
Mm-hmm.
We've got a good amount of information here looking at how WTO rules try to navigate this tricky balance.
Right.
You've got the benefits of open trade, more goods, cheaper goods, better goods, economic growth, all that.
Sure, the standard arguments.
But then, on the other hand, you have this very real need for countries sometimes to, shield their own industries when there's a sudden unexpected flood of imports causing serious problems.
Exactly. And safeguard measures, you can almost think of them as a kind of economic pressure valve, maybe?
Pressure valve, I like that, yeah.
The overall push is towards open markets, sure, but these measures accept that sometimes specific industries just get overwhelmed, even by imports that are traded perfectly fairly.
Right.
And, without this kind of safety mechanism, the whole project of trade liberalization might face, well, a lot more resistance.
Okay, pressure valve. So, our sources point mainly to Article 19 of the GARE 1994. That's the main rule book for goods trade. And then there's the specific agreement on safeguards for the details.
That's the legal framework, yeah.
Now, a really key point straight away.
Yeah.
These aren't for tackling things like dumping or subsidies, right? This is different.
Fundamentally different. Anti-dumping, countervailing duties, those are about unfair practices. Leveling a tilted playing field, so to speak.
Okay.
Safeguards, though, they acknowledge that even totally fair competition can sometimes just, boom, create unforeseen, really severe economic hardship for a specific sector.
So it's the volume and speed of fair trade causing the problem.
Exactly. And the ability for governments to react to that kind of economic emergency without just tearing up all their trade commitments, well, that's why this mechanism is actually pretty important for keeping the whole system going. Makes it more sustainable politically.
It's about giving that industry a temporary breathing space, maybe, a chance to adapt.
That's the idea, a temporary shield.
Now, our material notes, these aren't currently in GATS, the services agreement, but our focus today is definitely on goods trade. So let's drill down. What exactly makes something a safeguard measure under WTO rules? What are the sort of essential ingredients?
Okay, so at its core, a safeguard measure is a temporary government action. Usually, it involves suspending a trade concession, like a promised tariff rate or maybe modifying it, often by raising tariffs.
Right.
And it has to be specifically designed to prevent or to remedy serious injury or the threat of serious injury to a domestic industry. And crucially, that injury must be caused by an increase in imports of that specific product.
Okay, caused by the imports.
Yeah. The Indonesia iron or steel case from 2018 is a good example of what isn't a safeguard, actually.
Oh, right. How so?
Well, Indonesia hadn't actually lowered its tariffs on that particular steel product as part of a WTO deal. So when they raised the duty, it wasn't seen as suspending or withdrawing a concession. It has to link back to a commitment made previously.
Okay, so it has to be connected to a promise you already made in a trade agreement.
Precisely.
And it sounds like this area can get contentious. I mean, our notes mention the U.S. steel and aluminum disputes,
Oh, definitely.
where other countries were basically saying, hey, these U.S. tariffs look an awful lot like safeguard measures, but the U.S. was arguing, no, this is national security.
Exactly that. And that highlights this natural tension, doesn't it, between a country's right to protect an industry in, specific dire situations and the need to keep the overall global trading system predictable and rules-based.
Yeah, because if you can just slap a different label on it.
Right. If countries could easily just relabel trade restrictions, it would really weaken the rules that are meant to govern when you can legitimately use a safeguard. Big implications.
Okay, so we get the purpose, the general idea.
Yeah.
Now, how does a country actually, put one of these things in place? Our material seems to break it down into three main buckets of rules.
That's right. You've got, first, the substantive requirements, the economic conditions that must exist.
Okay.
Second, the procedural requirements, the actual steps, the process a country has to follow.
Right, the bureaucratic bit.
Well, the due process bit, yeah.
Yeah.
And third, there are rules about the measure itself, its form, how far it can go, and how long it can last.
Okay, let's tackle those substantive requirements first. What economic stars need to align for a country to even think about a safeguard?
Well, the first trigger is, unsurprisingly, an increase in imports. But WTO rules are quite specific here. It can't just be a gradual rise.
Not just business as usual getting a bit tougher.
No, it has to be a recent, sudden, sharp, and significant surge. You're looking at both the rate of increase, how fast it's climbing, and the overall amount.
So, a real spike.
Exactly. Think about those charts in our material, the Industria versus Agricola smartphone imports.
Right, yeah.
Industria shows that dramatic, almost vertical climb. That's the kind of sudden shock the rules anticipate. Agricola's chart, much more of a gentle slope, a gradual trend, that probably wouldn't cut it.
Okay, so you need that sharp increase. Does it matter if it's just more imports overall or imports taking more market share?
It can be either. It can be an absolute increase, just a higher quantity coming in, or it can be relative to domestic production, meaning imports are grabbing a much bigger slice of the home market.
Gotcha.
And here's a really crucial bit. The import surge must be the result of unforeseen developments.
Unforeseen developments. That sounds potentially tricky to define.
It can be a point of argument, absolutely. But the idea is that safeguards are for genuine, unexpected crises,
Hmm.
not for dealing with, say, a long-term decline in an industry's competitiveness or shifts in the market that everyone saw coming. It has to tie back to that emergency nature.
Okay, so unforeseen surge in imports. What's next?
The second big substantive requirement is serious injury, or at least a credible threat of serious injury to the domestic industry.
And how do they define domestic industry here? Is it every company in the country making anything similar?
No, it's more specific. It refers to the producers within the country who make like or directly competitive products, and their combined output has to make up a major proportion of the total domestic production of those products.
Like we're directly competitive.
Yeah, think about that Phone Smart and ePhone example in Industria. They mostly make single-screen phones, right?
Right.
And they're getting hammered by a sudden surge of imported dual-screen phones. Those dual-screen phones are arguably directly competitive. So even if PhoneSmart and ePhone only account for, say, 45% of all smartphone production in Industria, they could still be the relevant domestic industry for a safeguard investigation because they make the directly competing product and represent a major chunk of that specific segment.
Okay, so it's focused on the producers of the products that are actually competing head-to-head with the import.
Exactly.
Now, serious injury, that sounds
That is.
more than just feeling the pinch from competition.
Definitely. The standard is significant overall impairment in the position of that domestic industry. It's a deliberately higher threshold than the material injury standard you see in anti-dumping or countervailing duty cases.
Why the higher bar?
Because remember, safeguards apply to fairly traded goods. You're interfering with normal, legitimate trade, so the justification has to be stronger. The injury needs to be genuinely serious.
Okay. And what about the threat of serious injury?
That's even tougher to prove. A threat has to be clearly imminent. It means the serious injury isn't just a possibility down the road. It's, basically on the doorstep. And there's a very high degree of likelihood it's going to happen very soon if nothing is done.
Wow, okay. So not just speculation. What kind of evidence do investigators look for to determine if there's serious injury or a threat?
They examine a whole range of objective economic factors, things like the rate and amount of the import increase itself, the share of the market imports have taken,
Mm-hmm.
changes in sales levels, production, productivity, how much capacity is being used, profits and losses, employment levels within that domestic industry. It's a pretty comprehensive list, though not necessarily exhaustive.
And do all those factors have to be pointing downwards?
Not necessarily every single one, but the overall picture, looking at all the relevant factors together, must clearly show that significant overall impairment or that the threat is clearly imminent.
Got it. So we need increased imports, unforeseen, causing serious injury or threat thereof. What's the final piece of this substantive puzzle?
Causation. You have to show a clear causal link between that documented increase in imports and the serious injury or threat you've identified.
The imports have to cause the injury.
Yes. And importantly, there's also a requirement for non-attribution. This means investigators have to separate out any injury being caused by other factors. You can't just blame the imports for problems that are actually caused by something else.
That sounds really difficult in practice. How do you possibly untangle all the different things affecting an industry?
It is incredibly challenging. That industrious smartphone example again really shows this. The local industry is suffering, yes, and imports are surging. But there's also that NGO campaign pushing people to buy secondhand phones. And the local companies maybe haven't kept up with battery technology. Plus, there are new government regulations adding costs.
So lots of things happening at once.
Exactly. The investigating authority has the tough job of carefully analyzing all these factors and separating out their effects. They have to ensure that any safeguard measure is only addressing the injury genuinely caused by the increased imports. There needs to be, as the cases say, a genuine and substantial relationship of cause and effect between the imports and the injury.
You can't just use imports as a scapegoat for other internal problems.
Precisely.
Okay, so those are the big economic hurdles you have to clear. What about the process itself? How does a country go about investigating and potentially implementing a safeguard?
Right, the procedural requirements. These are really about ensuring transparency, fairness, and due process. First off, there has to be a proper investigation conducted by the country's competent authorities.
Like a trade ministry or commission?
Usually, yes. And critically, all interested parties have to be given a fair chance to participate. That means the domestic producers asking for protection, but also importers, exporters, foreign producers, anyone with a stake in the outcome. They need to be able to present evidence and make their case.
So everyone gets a say.
They should, yes. And after the investigation, the authorities have to publish a detailed report. This isn't just a summary. It has to lay out all their findings and reasoned conclusions on those substantive requirements we just talked about. The import surge, the serious injury, the causal link, the non-attribution analysis.
So no secret decisions. It all has to be out in the open.
Transparency is key. Then there's a vital notification step. The country planning to impose a safeguard must immediately notify the WTO's Committee on Safeguards.
Tell the WTO what they're doing.
And provide details, like exactly which product is involved, the evidence showing serious injury, what measure they plan to use, how long they intend for it to last, and crucially, a timetable for phasing it out or liberalizing it over time.
So they have to plan the exit strategy from the start?
Ideally, yes. And one more big procedural point. Before actually imposing the measure, the country must hold consultations with other WTO members whose trade would be significantly affected by it.
Talk to the countries whose exports you're about to restrict.
Exactly. Give them a chance to discuss it beforehand. So it's not meant to be a purely unilateral shock to the system. There's an obligation to engage internationally.
Okay, that covers the process.
Mm-hmm.
Now let's talk about the measure itself. What can it look like? How strong can it be? And how long can it stick around?
Right. So remember, safeguards are temporary import restrictions. Their goal is to give that domestic industry breathing room to adjust. The most common forms are either raising customs duties above the levels the country promised the WTO, breaking the tariff binding, essentially, or imposing quantitative restrictions like import quotas.
Things that would normally violate basic GATT rules, like Article 2 on tariff bindings or Article 7 on quantitative restrictions.
Precisely. But they're allowed under the safeguard rules if all those strict conditions we discussed are met.
Okay. Now, our notes mention something called provisional safeguard measures. What's the deal with those? Are they like an emergency measure?
Kind of, yeah. They're for what the agreement calls critical circumstances. That's where any delay in putting a measure in place would cause damage that's difficult or impossible to repair later.
Okay.
If those critical circumstances exist and a preliminary investigation finds clear evidence that the import surge has caused or is threatening serious injury, then a country can put on a provisional measure. But there are tight limits.
What kind of limits?
They can only last for a maximum of 200 days, and they can only take the form of increased tariffs, no provisional quotas allowed, and critically, a full, proper investigation still has to happen afterward.
So it doesn't replace the full investigation?
Not at all. And if that full investigation ultimately concludes that actually the conditions for a safeguard weren't met, then any extra duties collected under the provisional measure have to be refunded.
Okay, so it's a very short-term stopgap for truly urgent situations, with a money-back guarantee if it turns out it wasn't justified.
That's a good way to think about it.
What about the extent of a safeguard measure, whether provisional or final? Can a country just whack on a massive tariff or slash imports to zero?
No, definitely not. The rule is that the measure must only be applied to the extent necessary to prevent or remedy that serious injury and to facilitate the adjustment of the domestic industry. It has to be calibrated to the problem.
Not overkill.
Right. If it's a quota, for instance, it generally shouldn't restrict imports below the average level of the last 3 representative years unless there's a really clear justification for why a lower level is needed. And again, crucially, the measure can only target the injury caused by the increased imports. It can't be used to fix other problems.
Okay. Now, a fundamental principle in the WTO is non-discrimination, treating all trading partners equally. Does a safeguard have to apply to imports from all countries?
That is the general rule, yes. Non-discriminatory application, or MFN, most favored nation treatment. Typically, a safeguard measure should hit imports of the specific product from all sources equally.
So even if the surge is mostly coming from country A, the higher tariff would usually apply to country B and country C too.
Mm.
Using our Alpinia example, if Industria puts duties on smartphones, it hits everyone.
Generally, yes, that's the default principle. It avoids targeting specific countries, which could lead to trade disputes.
But I sense there are exceptions coming. Our notes mentioned the couple.
There are. Two specific, narrow exceptions allow for some selectivity. First, if the investigation clearly shows that imports increase disproportionately from certain specific countries.
So maybe 90% of the surge is from country A.
Right. In that situation, if the safeguard takes the form of a quota, it might be possible to apply that quota only to those specific countries causing the disproportionate increase.
Okay, exception one. What's the other?
The other exception relates to developing countries. Imports from a developing country member can generally be excluded from a safeguard measure if that country's share of imports of the product is small, specifically, less than 3% individually.
Ah, so small suppliers get a pass.
Yes, provided that developing countries with less than 3% import share collectively don't account for more than 9% of the total imports of that product.
Okay, so some protection for smaller developing country exporters. And if you do use a quota, how do you divide it up among the countries that are subject to it?
Well, the rules for allocating quota shares among supplying countries aim for fairness, trying to maintain the usual trade patterns as much as possible. They're similar to the general rules for administering quotas found in GATT Article 13.
Okay, so some complex rules there too. Now, duration. How long can these things last? They're meant to be temporary.
Absolutely temporary. The rule is only as long as necessary to prevent or remedy the serious injury and allow the domestic industry to adjust. There's an initial maximum period. 4 years, that's the longest it can be imposed initially.
Can it be extended?
It can be, yes.
Yeah.
But only if the authorities conduct another review towards the end of the initial period and determine, first, that the safeguard is still necessary to prevent or fix the injury, and second, that there's actual evidence the domestic industry is making adjustment efforts.
So you can't just keep it going indefinitely if the industry isn't trying to adapt.
Exactly. And even with extensions, there's an absolute maximum duration.
Right.
8 years in total. That includes the initial period and any extensions. For developing countries applying safeguards, the maximum is slightly longer, 10 years.
8 years or 10 for developing countries, that's it.
That's the absolute cap. And then generally, once a safeguard measure on a product expires, you can't just impose another one right away on the same product. There's usually a cooling off period.
How long is that?
Typically, the cooling off period has to be equal in length to the duration of the safeguard measure that just expired. So if you had a 4-year safeguard, you generally have to wait another 4 years before applying another one to that same product. Again, there are some slightly more flexible rules for developing countries here.
Right, so you can't just keep cycling through safeguards on the same product indefinitely. Now, what about the countries on the receiving end? The exporters, whose products are now facing higher tariffs or quotas. Does the country imposing the safeguard just get away with it?
Oh, definitely not. Because safeguards restrict fair trade, they're seen as upsetting the balance of concessions agreed upon in the WTO.
Right, it breaks a promise, essentially.
In a way, yes, albeit a permitted break under strict conditions. So the country imposing the safeguard has an obligation to consult with the exporting countries that are significantly affected. The purpose is usually to try and agree on some form of compensation.
Compensation? Like what?
Yeah.
Paying them money?
Not usually direct payments. More typically, it involves the country imposing the safeguard offering trade concessions on other products that are important to the affected exporters. Like, okay, we're raising tariffs on smartphones, but to make up for it, we'll lower our tariffs on your agricultural exports.
Trying to rebalance the deal.
Exactly. Trying to maintain a mutually advantageous balance of concessions overall.
And what if they can't agree on compensation?
Well, if those consultations don't lead to an agreement, then the affected exporting countries have the right under the Safeguards Agreement to retaliate.
Retaliate? How?
They can suspend substantially equivalent concessions or other obligations they owe to the country that imposed the safeguard. Basically, they can raise tariffs or restrict trade on products coming from the country that applied the safeguard.
Tit for tat.
Pretty much, yes. The retaliation has to be broadly equivalent in trade value to the damage caused by the safeguard. You saw this play out, or at least the threat of it, with the responses by countries like Turkey, Japan, the EU, and others to those U.S. Section 232 tariffs in 2018.
Right, because they argued the U.S. tariffs were really safeguards in disguise.
Exactly. And since the U.S. hadn't followed safeguard procedures or offered compensation, they claimed the right to retaliate. It highlights that imposing these measures, even if arguably justified, can come with real consequences if not handled according to the rules or if compensation fails.
Okay. So potential countermeasures are definitely part of the picture.
Yeah.
Finally, our notes just briefly touch on special safeguard measures. Are these different animals altogether?
Just a couple of specific variations to be aware of. Article 5 of the Agreement on Agriculture allows for what's called a Special Agricultural Safeguard, or SSG.
Okay.
It applies only to certain agricultural products that were subject to tarification during the Uruguay round negotiations. The trigger mechanisms are a bit simpler, often based just on import volume or price triggers, not necessarily requiring an injury investigation. But they are also quite narrowly defined and only available to countries that specifically reserve the right to use them.
So a specific tool for agriculture under certain conditions.
Mhm.
Anything else?
There was also a transitional product-specific safeguard mechanism that applied specifically to imports from China as part of the terms of China joining the WTO. But that was time limited and it actually expired back in 2013, so it's no longer operational.
Got it. So mainly the general rules we've discussed, plus that specific one for agriculture for some countries.
That's the current landscape, yes.
Okay. So wrapping this up, it seems safeguard measures are this very carefully constructed, carefully regulated instrument. They're meant to be a temporary fix for a very specific problem, serious harm from a sudden flood of fairly traded goods, and they come with a whole host of conditions attached.
That's exactly right. They really do embody this constant balancing act within the WTO system. On one side, you want to let countries protect their industries from genuinely unexpected, damaging import surges.
Right.
But on the other side, you need to make sure these measures aren't just abused as an easy way to backslide into protectionism against fair competition, hence all the strict rules.
Okay, so let's quickly recap for everyone listening. Safeguard measures.
Hmm.
They're a temporary tool for protecting domestic industries from serious injury caused by a sudden, sharp, significant increase in fairly traded imports.
Key points, yes.
They are governed by really strict rules about proving that import increase, proving the serious injury, and proving the causal link between the two
Yeah.
while separating out other causes.
The non-attribution part.
Crucial.
Right. Then there are detailed procedures, investigation, hearings, notification, consultation, and strict limits on how long the measures can last, how strong they can be, and generally, they have to apply to imports from all countries, though with those couple of specific exceptions we talked about. And finally, the country imposing the safeguard might have to offer compensation, and affected countries might be able to retaliate if things aren't worked out. So understanding all these intricate rules is, well, it seems pretty crucial if you want to grasp the realities of international trade regulation. It's all about that balancing act.
Couldn't have said it better myself. It's complex, but it's designed to be. So on that note, here's maybe a final thought for you, listener, to ponder. We're hearing more and more discussion these days about countries using other exceptions in WTO law, maybe things like national security exception.
That's definitely a trend.
How might the existence of these very detailed, quite demanding rules for safeguards influence whether a country decides to try and use those other exceptions instead? Exceptions that might seem, on the surface at least, a bit less restrictive or clearly defined.
That's a fascinating question. Does the difficulty of meeting the safeguard standard push countries towards other justifications?
Right. And what are the bigger implications for the whole global trading system, for its stability, its predictability? If the lines between these different kinds of trade restrictions start getting blurry, when is a safeguard, and when is it something else entirely?
That's a huge question facing the system right now. Definitely something worth thinking more about.
Indeed. So if you want to dig deeper into this, we definitely encourage you to look up some of the specific WTO cases mentioned, or even read the full legal texts of the JTT and the Agreement on Safeguards. They're all publicly available. Thanks for joining us for this deep dive into safeguard measures.